Good afternoon. On October 7, 2023, Israel experienced a brutal attack by Hamas militants from Gaza. Reacting, Israel's military initially, and then the government, issued both a declaration of war and a declaration of a special situation on home front, which is declared where there is a high probability that an attack will occur on the civilian population. These declarations enabled immediate recruitment of reservists and the adoption of emergency measures to protect the public. In this webinar, I will address the legal procedures and the effect of a declaration of war and of special situation concerning the Home Command under Israeli law. I will provide information on a variety of measures adopted in response to the situation, including expanding authorities for detention of terrorists affiliated with Hamas, Islamic Jihad, and other designated terrorist organizations, cybersecurity and increased surveillance procedures, and the adoption of restrictions on systematic, continuous consumption of terrorist publications and on operation of foreign broadcasters that harm state security. I will also talk about employment protection granted to certain groups affected by the taking of hostages on October 7, the evacuation of thousands of Israelis from their homes in southern and northern Israel, and the extended periods of military service on the reserve required by the war. The toll on human life and the economic impact of prolonged reserve service have heightened the public controversy regarding the uneven enforcement of the draft. Students who are from ultra-Orthodox communities known as Haredi have traditionally been exempted from the draft and granted financial subsidies directly connected to their exemptions. I will explain the evolution of the draft exemption and the Supreme Court's recent determination of its illegality. So let's begin. At 8 a.m. on October 7, the Minister of Defense issued a declaration of a special home front situation in the Gaza border region. At 6 p.m. that day, the Minister for National Security conveyed to the Israeli Police Commissioner that he had declared a civil emergency event throughout the state of Israel. At 8 p.m., the Defense Minister declared an expansion of the special home front situation to apply to the entire country. On October 8, the Israeli government passed Resolution 941, which extended the application of the special home front situation initially declared by the Minister of Defense. On the same day, the Israeli cabinet confirmed a state of war effective 6 a.m. on October 7, 2023. The decision was issued in accordance with Section 40 of Basic Law of the Government as amended. In accordance with Section 40C of the Basic Law, the government's decision to go to war must be conveyed as soon as possible to the Knesset, that's Israel's parliament, Foreign Affairs, and Defense Committee. The Prime Minister is also required to deliver an announcement to the Knesset plenum as soon as possible. The declaration of special situation in Home Command was issued based on the Civil Defense Law 5711-1951. The authority to declare a special situation on the home front is granted by law to the government or to the defense minister if the government has not declared it, and must be approved by the Knesset Foreign Affairs and Defense Committee within 5 days. A declaration by the defense minister expires within 48 hours unless extended to 5 days by the government. A further extension requires a decision by the Knesset Foreign Affairs and Defense Committee. Along the authorities that may be exercised by the Israel Defense Forces, IDF, in the area subject to the special situation in Home Command are the ability to require civilians to stay in shelters, to prohibit or restrict studies in educational institutions, and to prevent entry or exit from certain areas to save life or property. About 2 months into the war, on December 18, 2023, the Knesset passed Amendment Number 4 to the Detention of Unlawful Combatants Law of 2002 as amended. The law states that it is intended to regulate the imprisonment of unlawful combatants who are not entitled to the status of prisoners of war in a manner consistent with the obligations of the State of Israel under international humanitarian law. According to the definition in the law, an unlawful combatant is, quote, a person who takes part in hostile activity against the State of Israel, directly or indirectly, or who belongs to a force engaged in hostile activity against the State of Israel, but does not meet the conditions granting the status of prisoner of war under international humanitarian law, as detailed in Article 4 of the Third Geneva Convention of August 12, 1949, regarding the treatment of prisoners of war, end quote. Members of designated terrorist organizations, like Hamas, Islamic Jihad, or Hezbollah, may be considered unlawful combatants under this definition. The law authorizes the IDF Chief of Staff to issue a detention order when there are, quote, reasonable grounds to believe that an inmate is an unlawful combatant and that their release would harm state security, provided that the Chief of Staff does not issue such an order until the inmate has been given an opportunity to voice their arguments in this regard before an officer with the rank of lieutenant colonel or higher authorized by the Chief of Staff, end quote. The detention order must include the reasons for the detention without harming the needs of state security. If issued in the absence of the detainee, the order must be brought to the detainee's attention at the earliest possible date. The detainee will be released within 96 hours after being detained, unless a detention order was issued or earlier based on a decision by the Chief of Staff. A detainee is entitled to meet with a lawyer at the earliest possible time and no later than 7 days after detainment. This period may be extended to 10 days for reason of state security or to preserve life by an IDF officer with the rank of colonel or above, or by the head of the Israel Security Agency, the ISA, Department of Investigators, as determined by the law. A 2008 amendment of the law authorized the government to declare the existence of, quote, widespread hostilities, end quote, resulting in implementation of more flexible arrangements. These include the delegation of detention authority otherwise reserved to the Chief of Staff to an officer with the rank of Brigadier General, and that reserved for an officer with the rank of Lieutenant to an officer with the rank of a Captain. The 2008 amendment further extended the period in which an unlawful combatant could be detained without a detention order from 96 hours to 7 days. The 2023 amendment law replaced the declaration of, quote, widespread hostilities with a statement by the government or by the ministerial committee under conditions provided that the application of certain enumerated provisions under the law is necessary following the government's, quote, decision to start the war, take significant military action, or take other military actions in accordance with Section 40C of Basic Law of the Government. The colonel or the head of the ISA team of investigators would also be able to exercise detention authority previously requiring higher-ranking officers. The 2023 amendment law further extended the period of 96 hours after which a detainee must be released in the absence of a detention order to 45 days, but declares, quote, that a temporary detention order shall not remain in effect for a period exceeding 30 days unless issued or extended by an officer with the rank of a major or higher, end quote. The amendment also extended the period within which a detainee must be brought before a judge from 14 to 75 days, and the period within which a detainee may meet with an attorney from 7 to 30 days under conditions enumerated. And finally, the 2023 amendment law authorized court hearings to be conducted under the law by way of video conferencing. The detention of unlawful combatants law requires that detainees would be held in appropriate conditions that will not harm their health and dignity. The law authorizes the Minister of Defense to issue regulations regarding the implementation of this requirement. Regulations issued in 2002 regulate the rights of inmates to food, medical examination and treatment, hygienic conditions, outdoor walks, personal belongings and worship, as well as to a visit by a lawyer, by family, and by the International Committee of the Red Cross. Last week, Israel's High Court of Justice issued a decision clarifying that the dire situation of the war, which so far lasted for over 11 months following the October 7 Hamas attack, did not justify deviation from the law and the regulations. The case centered on the operation of the Sde Teiman military base in the Negev desert. Sde Teiman was declared a detention facility in accordance with the law on October 8, 2023, the day after the Gaza war began, and the declaration has been extended periodically since then. The facility was intended to serve as a reception, interrogation, and preliminary screening facility for prisoners captured in the war for a limited time before their transfer to the Israeli prison service or release back to the Gaza Strip. According to the petitioners, the state has systematically and continuously violated the prison conditions guaranteed in the law and the regulations, harming detainees' lives and bodily integrity. The petitioners alleged that the detainees had been deprived of adequate food when they were fed blindfolded and handcuffed, that they had been physically punished, and that the medical care provided was inadequate. In response, the state argued that this was necessary for detainees to be held in the facility for longer than the original purpose of their incarceration because of the unprecedented number of persons detained during the war and the shortage in prison facilities. The state said it had been taking steps to transfer detainees to another facility and to improve the infrastructure at the Sde Teiman facility, including its medical facility. The state also argued that it had complied with the main requirements of the regulations, including not carrying out physical punishment in the facility, photographing the facility's compounds regularly, and maintaining hygiene conditions. Regarding handcuffing, the state said an updated directive provides that after 96 hours, detainees must be held without restraints unless there is a specific justification for doing so. The court declined to close the facility, but stated that its continued operation was conditional upon compliance with the law. Acting Court President Uzi Vogelman rejected the state's claims that if there were gaps in implementing the regulations at Sde Teiman, the failures did not implicate the regulation's core operations. According to Justice Vogelman, the state does not get to decide, quote, which provisions of the law it is obligated to comply with and which it is not, end quote. He reiterated the Supreme Court's statement that, quote, even when the cannons thunder and the muses are silent, the law exists and operates and determines what is permissible and what is forbidden, what is legal and what is illegal, end quote. Vogelman observed, however, that since the filing of the petition, the conditions in the facility had changed significantly, both with respect to the number of inmates and the infrastructure. He said the court was not deciding the case based on the serious factual allegations raised in the petition, and he assumed that such allegations would be discussed by other review mechanisms, including relevant criminal investigations. Concurring with Vogelman, Justice Daphna Barak Erez said that she recognized the challenges associated with the detention of suspected terrorists during these, quote, difficult and bitter days of war, and more so when our brothers and sisters languish in cruel captivity in the Gaza Strip. However, continued the quote, unlike terrorist organizations, the state of Israel is a state of law, and this too is its power, end quote. I want to mention in this context that the Israeli government issued a blanket ban on Red Cross visits for Palestinian prisoners following the October 7 Hamas massacre. In an order issued on August 25, 2024, the High Court ordered the government to explain why it should not declare its ban on Red Cross visits to be illegal and why it should not provide the Red Cross with details of all the Palestinian prisoners and detainees currently being held by Israel. I will be following developments in this regard and report on them at the Law Library of Congress Global Legal Monitor online publication, which I will discuss later in this presentation. Since October 7, there has been an increase in the scope and intensity of cyber attacks against civilian entities in the Israeli economy. In response, on December 25, 2023, the Knesset passed legislation to regulate procedures for the handling of serious cyber attacks. The law will remain in effect until March 31, 2025. According to explanatory notes of the Law for Handling Serious Cyber Attacks in the Digital Services and Data Storage Sector, Temporary Order, Iron Source, 2023, such attacks are part of a coordinated attack against the resilience of the State of Israel, its economy, and the proper functioning of the Israeli market. Quote, cyber attacks may lead to damage to cyberspace, physical harm, for example, damage to medical systems or energy infrastructure. It may also lead to severe impairment of the functioning of the economy and even harm to life. Cyber attacks are becoming more sophisticated, and their consequences are more difficult and complex. Companies that provide digital and storage services are characterized by high connectivity to many entities in the Israeli economy, including government ministries and public bodies, and security and critical state infrastructure and organizations that are essential to the functioning of the economy. Due to this connectivity, the damage caused by attacking these companies may spread and affect many companies, end quote. The temporary order for handling serious cyber attacks in the digital services and data storage sector authorizes the respective heads of cybersecurity department at the ISA, Israel Security Agency, IDF, and National Cyber Directorate, or the Director of Security of the Defense Establishment, to declare that a serious cyber attack has occurred or is imminent. A declaration may be issued upon finding that there is a real concern, I'm quoting, based on all of the following, that the attack could harm state security, public safety, or the maintenance of essential supplies and services. And one, the attacks occurrence during the period of significant military operations, as determined by the government, in this case on October 8, 2023. And secondly, that the existence of a real concern that the attack could have a significant impact that is not limited to the attacked provider. A third condition could be that its characteristics, including its outline or the identity of the attacker. A provider may be informed of the issuance of a declaration in order to detect, prevent, or stop the attack within a specified reasonable time. Who is considered a provider under the law? First, it could be a person who is engaged in providing storage or digital services and whose computers have a physical or logical, permanent or periodic connection to the computers of his service recipients, or whose computers engage in permanent or periodic transfer of computer materials to the computers of his service recipients. A provider could also be a person who is engaged in providing maintenance, management, or control of storage services or digital services. A provider who has been ordered to act must provide information on the measures they had taken as prescribed by the law to ensure, quote, with a high degree of probability that the impact of a serious cyber attack beyond the attacked provider will be limited and that the attack will be handled appropriately, end quote. A provider who fails to comply with the above may be instructed, after being given an opportunity to be heard, to carry out specific cybersecurity activities or deliver a copy of computer software or information. The law requires the authorized bodies to report monthly to the Attorney General and to the Knesset Foreign Affairs and Security Committee regarding the number and types of cases where instructions were given to providers, also to report on the rate of compliance and on the number of cases involving serious cyber attacks categorized according to the harm caused to state or public security or the impairment of maintaining essential supplies and services. Additional measures taken after the October 7 attack were intended to enhance surveillance and cybersecurity to protect public security and the Israeli economy. A temporary order adopted on December 6, 2023, permitted, under certain conditions, to penetrate computer material that is used for operating a stationary camera. Such permission is an exception to the computer law and the Criminal Procedure Search and Seizure Ordinance that prohibit the penetration of computer material in the absence of a judicial warrant. According to the explanatory note of the draft bill, the need for the special authorization reflects a real concern over the access of enemy elements to visual information produced by stationary cameras, which could impose a substantial danger to the security of the state and the continued operation functioning of the IDF. The 2023 amendment authorizes the IDF and the Israel Security Agency to penetrate either electronically or by activating computer software or information that is used for operating stationary cameras. The law further authorizes, under conditions enumerated, the deletion of, alteration of, disruption of, or interference with such material. The authorization granted is in effect until December 31st, 2024, but may be extended for 3 additional months by the Minister of Defense due to the continuation of significant military operations. Securing an extension would require the consent of the Prime Minister and the approval of the Knesset Foreign Affairs and Defense Committee. So under what conditions may penetration into a computer be authorized? An IDF or an ISA competent official may approve a list of computers that would be subject to penetration. The law requires that it be shown that penetration of computer material and operating it are required immediately and urgently, and that it is not possible reasonably and within the necessary time to achieve the objective in another way that infringes rights to a lesser extent. The temporary order requires that the exercise of authority will be limited as necessary and for the shortest periods of time, and that the ability of the owner of the computer material to access visual information produced from a stationary camera should be restored to the extent possible, and all within a reasonable period from the end of the circumstances that necessitated the penetration and operation. Decisions regarding approval of penetration must be documented. In addition, the IDF Chief of the General Staff, the head of the ISA, or other designated high-level officials are required to provide a monthly report on implementation of relevant authorizations. The report must be submitted to the Subcommittee on Intelligence and Secret Services of the Knesset Foreign Affairs and Defense Committee and to the Attorney General. The report is confidential and must list the number of computers included in the list approved for penetration, must include the number of authorized soldiers or ISA employees as relevant and their duties, the types and number of operations they carried out, and any special events or malfunctions that occurred during the exercise of their power. An additional measure adopted in the context of the war was an amendment to the police ordinance to regulate the installation and use of special photography systems. I will refer to them as SPSs. Their installation and use by the Israel police in the public space. According to explanatory notes of the draft bill, the amendment was designed to maintain a proper balance between privacy rights and the public interest in preventing and detecting crime, adjudicating offenders, and protecting public order, persons, and property. The amendment law would reportedly provide a legislative basis and establish an oversight mechanism for the activation of systems such as the Hawkeye, which is based on an LPR, license plate recognition mechanism, that enables the tracking and identification of license plates and determining whether a vehicle was stolen or if its owner's driver license has expired. Activation of the Hawkeye had previously been controversial in the absence of regulation. The amendment law limits the installation and operation of stationary SPSs, including those with real-time alerts, to the following objectives: preventing, foiling, or detecting criminal offenses or offenses that may endanger the safety or security of a person, the public, or the state; identifying persons involved in planning or committing such offenses; preventing serious harm to the security of persons or property when there is a real concern for their safety; locating a missing person or a person at risk; and also enforcing prohibitions or restraining orders against entry to public places. The operations of SPSs is subject to oversight by the Attorney General and the Knesset. The amendment law requires the Israeli police and public bodies that receive information retrieved by SPSs to annually report to the Attorney General on items including the number and the type of stationary and mobile SPSs activated, their objectives, and the number of bodies authorized to access its database containing information derived from SPS systems, listed according to their role and the details of their access permissions. The amendment law also imposes a duty on the Minister of National Security to report to the Knesset National Security Committee on the number of photographs used as evidence in investigation files, the number of cases in which an indictment was filed, the number of objects identified in an SPS, the number of persons authorized to access the information stored in SPSs, and the number of cases in which SPS was used to urgently handle a life-threatening event or an event that endangered state security. An additional measure taken following the October 7 massacre is the adoption of legislation criminalizing a systematically and continuous consumption of publications of a specified terrorist organization in circumstances indicating their identification with the terrorist organization. Under the Combating Terrorism Law, this is Amendment number 5 and Temporary Order of 2023, with effect for 2 years from November 12, 2023, the penalty for doing so is 1 year imprisonment. To constitute an offense, the publication must directly call for perpetrating an act of terrorism or express praise, sympathy, or encouragement for, or document the commission of such an act. Publications, quote, made at random, in good faith, or for a legitimate purpose, including for the purpose of making information available to the public, preventing the perpetration of terrorism offenses or research, end quote, are excluded from those that may trigger prosecution. Terrorist organizations are listed at the addendum of the law and include Hamas, ISIS, and others. Enforcement authorities under the amendment law are subject to parliamentary oversight. The Minister of Justice must report to the Knesset Constitution, Law and Justice Committee biannually about the number of investigations opened, the number of persons arrested, the number of indictment files, and the results of criminal proceedings held in the last 6 months of the preceding the reporting date. While some civil rights organizations criticize the law, arguing that it may lead to, quote, punishing people not based on their actions, end quote, the amendment's bill explanatory notes stated that, I'm quoting, the temporary order is intended to provide for a limited period another tool in the struggle against terrorism with an emphasis on individual attacks, which are characterized by perpetrators of acts of terrorism who do not belong to terrorist organizations, but whose motivation to perform the acts stemmed from intensive consumption of terrorist publications of terrorist organizations with certain characteristics. The need is intensified in light of the current security situation and concern that it could be exploited by those terrorist organizations. Intensive viewing of terrorist publications of certain organizations may create a process of indoctrination, a kind of self-brainwashing, which may bring the desire and motive to commit an act of terrorism to a very high level of maturity, with the final trigger that will bring the consumer of terrorist content to commit an act of terrorism being a random factor that may not be anticipated or prevented in advance, end quote, from the parliamentary explanatory notes of the bill. On April 1st, 2024, the Knesset adopted the Prevention of Foreign Broadcasting Entity Harm to State Security Law, to which I will refer to as the Foreign Broadcasters Law. The law is in effect until November 30th, 2024, the end of the declaration of special situation on the home front, or the conclusion of significant military operations, whichever comes first. The law authorizes the Minister of Communications, following a determination by the Prime Minister, based on the professional opinion of the IDF, ISA, or the Israel Secret Intelligence Service, the Mossad, that content broadcasted on a foreign channel in Israel harms national security in a substantial manner and with the approval of the Ministerial Committee for National Security or the government. So the authorization is first to instruct the provider of content to cease broadcasting such a channel or to order the closure of the offices of such a channel located in Israeli territory, to order the seizure of a device, or to instruct the responsible party, as defined by the law, to remove the website of such a channel if the server on which the website is stored is in Israel or is controlled by a person located in Israel or controlled by a corporation registered in Israel. Or also, it is possible to order that access to the website of such a channel be restricted. An order under the law becomes effective upon delivery to the broadcaster and must be published in the official gazette. It may be enforced for a period not exceeding 45 days, but may be extended for additional periods of up to 45 days each, under circumstances specified in the law. An order for extension under the law must be brought to the attention of a district court judge within 24 hours. Orders to shut down the operation of the Qatar-based Al Jazeera channel in Israel were issued in April 2024 and since renewed. In another development, on August 11, 2024, Israel blocked the Hezbollah-affiliated news channel Al Mayadin, citing reasons of national security in accordance with the Foreign Broadcasters Law. On June 4, 2024, the court upheld orders issued on May 5, 2024, by the Ministry of Communications to shut down Al Jazeera broadcasts, close its Israel offices, block access to its websites, and seize equipment. The court observed that the temporary order granting the government the power to significantly infringe on freedom of the press was adopted in the exceptional circumstances of the war following the Hamas attack on October 7, 2023, and were for a limited time. The orders were based on a determination that the network's broadcasts substantially harm state security. According to Judge Yaniv, freedom of the press and freedom of expression in the media have been recognized by Israel's Supreme Court as central values in a democratic country. The right to freedom of expression, like other constitutional rights, however, is not absolute. Israel's Supreme Court has previously determined that, quote, democracy must be tolerant of the intolerant, but democracy should not allow its tolerance to destroy itself. A constitution is not a prescription for suicide, and citizen rights are not a platform for national annihilation, end quote. As orders issued under the Foreign Broadcasters Law impact the right to freedom of expression and freedom of the press, Yaniv noted, they must rely on what he called powerful evidence. Such evidence must be convincing, clear, and unequivocal that the contents that are broadcasted substantially harm state security, end quote. Judge Yaniv found, based on his examination of data from what he termed as high-quality sources, including recently gathered information, that Hamas and Al Jazeera had an ongoing close relationship. In addition to the role played by Al Jazeera in inciting Hamas, the channel described, quote, in real time, end quote, the location of Israel Defense Forces operations, thereby endangering IDF soldiers. Al Jazeera also broadcasted instructions on how to hit an Israeli tank, pointing to its weakness points and explaining how rockets could penetrate the tank's, quote, 3 layers of defense, end quote. Given the unique complexity of wartime, Judge Yaniv concluded that a significant harm to state security takes precedence over freedom of expression. I will now turn to legislative protections for those impacted by the war. On May 28, 2024, the Knesset adopted the Veterans Return to Work Amendment number 19 and temporary order. The amendment expands permanent employment protections to reservists who have served in the IDF for extended periods of time following the October 7, 2023 Hamas massacre. According to explanatory notes to the draft bill, the amendment was intended to provide additional protections to reservists and their spouses who, in addition to their work, have had to bear the burden of caring for the family throughout the reserve period. As now amended, the law grants specific protections to veterans who are permanent employees in qualifying workplaces. The law prohibits the dismissal of employees because of their service in the reserves. It also prohibits dismissal during the period of an employee's reserve service and in the 30 days period following the end of the reserve service, unless permission is received from an employment committee. Such permission may only be granted based on special reasons to be recorded, and only upon proof that the dismissal was not triggered by the employee's reserve service. The law as amended also forbids reducing the scope of qualifying veterans' position or income, except in certain circumstances, which may include if the reduction was based on a law. This also applies if the reduction was based on a law or collective agreement, or where the veteran productivity fell for reasons not caused by the employer. The amendment further prohibits an employer from firing an employee because of the duration or frequency of the reserve service of the employee's spouse or of the co-parent or employee's child who is younger than 14 years or has special needs. A dismissal issued in violation of the protections of the law as amended is invalid. The dismissal or placement of on unpaid leave of an employee with whom the reservist has a child during the period of reserve service or within 14 days after its termination may, however, be authorized by the Ministry of Defense's Employment Committee in certain limited circumstances. The law imposes similar prohibitions and liability for compensation for dismissal of permanent employees of manpower agencies. On November 27, 2023, the Knesset passed an amendment to the Protection of Workers at the Time of Emergency law. The amendment applies retroactively as of October 7, 2023, and will remain in effect until October 6, 2024. According to explanatory notes of this amendment laws bill, the amendment law was intended to address the unique situation in which the families of the abductees, prisoners of wars, and missing in action find themselves by extending protections provided under the law to employees who were evacuated from their places of residence in specified localities following the terrorist attack and the security situation. The amendment law prohibits employers from dismissing any employee for absence from or non-performance of work if the employee first has been evacuated from their place of residence in specified communities, was pronounced abducted or missing in accordance with law, is a parent, spouse, child, sibling, or other family member of a person who has been pronounced abducted or missing, who is eligible for assistance under the law, and who has submitted a signed statement regarding their inability to appear for or to perform work because of family responsibilities related to their abducted or missing relative. And the fourth situation could be when the employee was absent from or failed to perform work to supervise their child while the employee's spouse or the child's other parent was engaged in military or other security service or service as an emergency essential worker, a first responder, or a member of the rescue, one of the rescue organizations. The war has required large mobilization of forces. 287,000 reservists were initially drafted in what has been reported as the largest ever call-up of reservists in Israel's history. As tensions ramped up along Israel's northern border with Lebanon, with Hezbollah launching missile attacks against Israeli villages and towns, the government has raised the number of reservists the IDF is authorized to call up in case of need from 300,000 to 350,000. Due to a shortage of troops, in August, IDF has begun calling on reservists up to the age of 35 who received an exemption from reserve duty to return to service. A total of 15,000 civilians, those who did regular service and received an exemption from reserve duty since they were released from compulsory service 14 years ago. Also, these were reportedly would now be called up for reserve duty in 3 phases in the coming year. As a rule, under the Defense Service Law, every Israeli citizen or permanent resident, 18 years or older, is required to serve in the IDF. First under compulsory service, and then as a reservist. The duration of mandatory service for male conscripts between the ages of 18 to 26, and for female conscripts who volunteer for certain IDF roles, is 32 months if drafted by July 1st, 2024, and 30 months after that date, with 24 months for female not in the selected roles. Different periods apply to physicians and dentists. In accordance with the Reserve Service Law, a reservist may be called to serve until the age of 40 and 45 for officers, and up to 49 for certain specified professions. An Army veteran who is found fit for military service will be included in the reserve system unless exempted. Maximum periods of reservist service in accordance with the law are generally 54 to 70 days within 3 consecutive years, and up to 108 days for certain designated professions. Longer periods may be prescribed in emergency situation by the Minister of Defense with government approval for reasons of state security. If pre-approval by the government cannot be obtained because of emergency, the order may be issued with the consent of the Prime Minister, but will expire within 7 days, unless approved by the government. The Minister of Defense must submit the order for approval by the Knesset Foreign Affairs and Defense Committee as soon as possible. The order will expire after 14 days from the date of issue, unless approved by the committee or by the Knesset. The government may also, upon determining that there exists a special situation, authorize the Minister of Defense to draft a reserve soldier who belongs to units, professions, and positions as determined by the order for purposes or periods that exceed those otherwise prescribed. The increased need of IDF and the extended duration of military service in the current war has intensified public objection to the exemption of Haredim, ultra-Orthodox yeshiva students, from the draft. The policy of exempting yeshiva students from the draft dates to 1949, when then Prime Minister and Defense Minister David Ben-Gurion decided to exempt about 400 yeshiva students from military service, reportedly to preserve Judaic studies in consideration of the destruction of the yeshivas in Europe during the Holocaust. The policy of exempting Haredim from the draft has been maintained by successive Israeli governments, with the number of exempted yeshiva students steadily increasing, reportedly reaching 60,000 by 2021. Many Israelis have resented what they perceive is an unequal treatment whereby the majority are drafted for at least 2 to 3 years, followed by extended periods of reservist service, while members of the Haredi community are exempted and receive financial subsidies directly related to their attendance at the yeshivas. Already in 1998, in Rubinstein versus Ressler, the High Court of Justice held that the policy must be regulated by primary legislation and not by governmental decisions. In 2002, the Knesset adopted legislation titled the Tal Law, after Judge Tzvi Tal, who headed the committee that proposed the law, which provided a statutory authorization to the Minister of Defense to approve yeshiva students' draft deferments for a period limited to 5 years. In a 2006 decision, the court held that the law violated the constitutional right to equality. In a 2012 decision, the court determined that the deferment arrangement provided under the law contained an inherent defect that could not be remedied and that the law could not be further extended. The law expired in August 2012. The court struck down an additional amendment which allowed further extension of the exemption policy in a 2017 decision. After approving multiple requests for extension of the law to allow the government to prepare alternative legislation, however, the law expired on June 30, 2023, before any alternative legislation was passed. 5 days prior to the expiration of the law, the government passed Resolution 682, Section 3 of which instructed the military not to enforce the provision of the law on yeshiva students, with effect until March 31st, 2024. Resolution 682 expired on April 1st. On June 25th, the High Court of Justice held that as provisions of the Defense Service Law regarding the deferment and exemption expired on June 30th, 2023, there was no longer any legislative arrangement that made it possible to distinguish between yeshiva students and others intended for military service. The court further determined that there was a direct link between governmental subsidies for yeshivas and military recruitment arrangements that delayed and exempted their students from service. In the absence of a legal basis for deferral or exemption from the draft, the basis for distribution of subsidies no longer existed. This webinar covered some of the legal developments associated with the war situation. I realize we covered a lot of topics. Before opening for Q&A, I would like to draw your attention to resources that are available on the Law Library website at www.law.gov on related subjects. These include reports, Global Legal Monitor articles on new legislation and court decisions, and our blog, In Custodia Legis, which contains several posts on Israel and other countries' laws. I will now respond to your questions as time permits. We don't have a lot of time, so if there are any follow-up questions, please use the write to us through Ask the Librarian address that I will show, which is posted on the next slide. Okay. So I have one question here. You mentioned the orders to shut down the operation of the Al Jazeera and Al Mayadin channels in Israel were based on authorities granted under the Foreign Broadcasters Law. Was the constitutionality of this law reviewed? So on June 9, 2024, the High Court of Justice ordered that a petition filed by the Association of Civil Rights in Israel challenging the constitutionality of the Foreign Broadcasters Law merits judicial review by an expanded panel because of what they said was the law's precedent-setting nature. I will be reporting on any developments on this issue in the Law Library's Global Legal Monitor when the court publishes its decision. I have a question here regarding the draft. What measures were taken to implement the general draft of yeshiva students following Israel's High Court of Justice decision that there was no legal basis for their exemption from the draft? So opposition to the draft seems to be persistent, and enforcement remains in doubt. Haredi parties are an essential part in Netanyahu's coalition government, and they have conditioned their support for the government under his leadership by ensuring Haredi's exemption from the draft and for the financial subsidies that are based actually on the number of Haredis that are exempted from the draft. So what happened following the court decision is that after receiving the military issued draft orders, and after receiving these orders in August, Haredi young men reportedly swarmed the draft center, and out of 900 summons initially following the court's ruling, only 48 showed up. In an effort to again prevent implementation of the High Court judgment, on August 5th, the government secretary Yossi Fuchs reportedly sent a letter to the Deputy Attorney General in which he argued that the High Court of Justice didn't actually rule that the government must recruit Haredim, but rather left it to the professional discretion of the military authorities. The Attorney General responded that the government secretary actually was not authorized to give a legal opinion to the government regarding the recruitment of yeshiva students, and therefore the government could not rely on his opinion. But as I mentioned, because of the important role of the Haredi parties in the coalition government, it remains to be seen, really, if and how the High Court decision will actually be implemented. I have here a question about detention. What are the conditions for prisoners of war status under international humanitarian law? Do members of Hamas and other terrorist organizations qualify as POWs under Israeli law? Well, the status of prisoners of war only applies in international armed conflict. Prisoners of war are usually members of the armed forces of the parties to a conflict who fall into the hands of adverse party. As a rule, combatants must distinguish themselves from civilian population. According to the International Committee of the Red Cross, however, it is clear that regular armed forces have to distinguish themselves from the civilian population during a military operation. But I want to mention here that Article 3 of the Geneva Convention, relative to the treatment of prisoners of war, does apply to an armed conflict not of an international character occurring in the territory of one of the contracting parties. So this article requires the persons taking no active part in hostilities, including members of armed forces who have laid down their arms, to be treated humanely, without any adverse distinction based on such grounds like race, and religion or faith, etc. So though members of Hamas and other terrorist organizations are not entitled to the status of prisoners of war, Israeli law and regulations on the detention of unlawful combatants, as I discussed earlier in this webinar, they are, the law and the regulation are intended to provide a legal framework for compliance with these requirements. As discussed before, the Supreme Court required that the military would comply with them, and any violations could be further adjudicated in criminal law or other venues. I think, let me see. Well, it's time, so maybe let me pick just one additional question, if this is okay with you, Barbara, that I will be done.
Sure.
Okay, I have here a question. Is there something equivalent to a conscientious objector in the US? Well, not exactly, except for the Haredi population that used to be, their service used to be deferred and then finally completely exempted based on their identification as people who studied the Torah in yeshiva, in institutions of high religious education. Let me pick just one more. So before October 7, there was a lot of action around the proposed judicial reform. Where is that conversation nowadays? Has the war and new situation changed or impacted the conversation about judicial reform in any way? Well, I hope that you listen. Last year, I gave a webinar on the proposed judicial reform. I believe they are available if you search the Library of Congress sources. The government or the judicial reform are still, some will say, live and so the Supreme Court has issued an opinion and this validated a law that was designed to make one of the grounds that was one of the issues of the judicial overhaul, the doctrine of reasonableness, that the court decided that avoiding this doctrine under Israeli law was not constitutional. These are a little complicated issue to discuss in this Q&A, but basically, other than that, efforts to change the composition of the Supreme Court are actually currently taking place with the Minister of Justice not convening a committee whose task is to select justices and to the Supreme Court and the president of the Supreme Court. This is like the Chief Justice here. So I hope this gives you a little bit of information on that, and I will be happy to provide any additional information to any of you if I have not had time to respond to you. I know that it's over the time by this time. Please, as I mentioned before, write to us. There is information, I believe, yes, here at this link, and we will be happy to respond to your questions. Have a nice afternoon.